Hello, everyone. This is John Holevoet from the Dairy Business Association. I want to thank you all for joining our monthly policy webinar series. This month's topic is the evolution of local government regulations. I'd ask that if you haven't already, please mute your phone line so as not to disturb the rest of us during the presentation. And we're going to jump right into it. I'd like to begin by thanking our sponsors. First of all, Compeer Financial, which has been sponsoring this entire series all year long, so we appreciate their ongoing support for the webinar series. And I also want to thank our new sponsor for this particular webinar, which is Nutrient Advisors. I know we have Kyle Govan online from Nutrient Advisors. I think Kyle wants to say a few words.
Good afternoon, everybody. I'm Kyle Goldman with Nutrient Advisors. I am the area manager in Wisconsin. Nutrient Advisors is a consulting company that provides compliance record-keeping services as well as nutrient management, manure management services, monthly consultation visits, as well as helping you through the permitting process as well as permit renewal processes. If you have any additional questions or anything, feel free to look us up.
Thanks, Kyle. We appreciate your sponsorship. I also want to thank my co-presenters for today's webinar. We've got both Dave Crass, a name known to most everyone on the call, a partner at Michael Best and Friedrich, as well as an associate at Michael Best and Friedrich named Paul Jonas. Dave works out of the Madison office. Paul works out of their Milwaukee office. They both work a lot with the agricultural community, the dairy community, and work on all kinds of issues relating to local control, local government regulations, and beyond. So we're looking forward to hearing their insights as we get into the material. Starting, of course, with a little bit of humor. Here we have a cartoon depicting the evolution of a parasite, probably a little harsher than we'd like to see treatment of our government officials, our bureaucrats, although certainly for some of us who've gone through the permitting process, sometimes it can feel that way. And here we're going to look at today sort of how local regulations should be structured, but also new developments and sort of the different directions in which local governments are trying to take regulation, some of which are probably not lawful, some of which are certainly not welcome by the regulated community. So there will be an opportunity to at least express probably a little disappointment and anger at some of what we're facing in when it comes to local government regulation and how it's developing. I want to begin by talking a little bit just about the birth of livestock facility siting. Around the turn of the century, this century, the 2000 mark, a group of progressive dairymen in Wisconsin were looking to expand and grow. And I think as they did that, and we saw some of our first larger farms sort of really take root here in the state, we also saw sort of this variety of different challenges they were facing from local governments, what started to be sort of a patchwork of different local government regulations. In that same time period, the DBA is formed in 2000, and one of the group's top priorities was actually try to create some uniformity here, try to standardize those local rules and make a more predictable environment for growing farms so that people could feel confident that if they wanted to grow in the neighboring county, they'd kind of know what they're getting into before they had to purchase land or anything like that. With that in mind, we worked hard to try and get a uniform livestock facility siting law. That bill passed in 2004. It took DATCAP 2 years to write all the administrative rules that support that statute, and that administrative rule that we have is ATC 51. So we're going to talk both about the statute and the rule a little bit. Starting with the statute, that's Section 9390 of Wisconsin statutes. It basically instructs DATCAP to develop rules for siting livestock facilities, and it gives them different goals to try to meet. And they're pretty extensive when you think about they really have to try and take all these things into consideration. So they're trying to protect the public health and safety, make practical and workable rules. They should be objective. They should be based on science. They should promote the growth and viability of animal ag, while also and try to balance the viability of farms with concerns for natural resources and community interests. And also they need to be usable for local political subdivisions, so they are easy to understand, easy to use, easy to implement. The most important part from my perspective of 9390 is this subsection here that's identified at the bottom, or the start of it's identified at the bottom of this slide, which is 9390 sub 3 sub A. And that basically shows a political subdivision may not disapprove or prohibit a livestock facility siting expansion unless, and then it goes on to give some exceptions. But what that sets up is actually this presumption that, generally speaking, we're going to try and get permitting allowed. That's the basic starting point, the fundamental basis of livestock siting, starting from a place of it's permissive to permit larger farms. The exceptions there are then outlined on the top of this slide, which is it's not an ag zoning district, or excuse me, a district that's zoned agriculture. It is a livestock facility that has more than 500 animal units and doesn't follow the rules of livestock siting, or it has more than 500 animal units but doesn't follow more stringent local standards that are adopted by the local government. One of the things that siting does is it sets out these basic standards for what should be expected of all farms, but then it also allows local governments that if they're able to show, based upon science, that they need to do something extra to protect public health and safety, they're allowed to do that. There's other exceptions too. Some counties had existing siting requirements, and those things were grandfathered in. I happen to live in one of those counties, which is Jefferson County. We had a much lower animal unit threshold, which we still have. So we were one of those rare exceptions that were grandfathered in. The law was not retroactive on existing facilities, although, well, I should say it wasn't. It wasn't automatically. So if you were over 500 animal units, you didn't have to automatically go and get a permit. But if you were over 500 animal units when the law was passed, if you grew an additional 20%, then that would trigger the requirement for you to get a permit under siting.
Hey, John, this is Paul Jonas at Michael Best.
Yeah, Paul.
So first of all, I wanted to thank you for the opportunity to speak to the group today. This is an area of law that's sort of become near and dear to my heart. So really appreciate the opportunity to talk to you all here this afternoon. I think that the section that you just highlighted of 93.9 and its corollary under ATCP 51, it's to me is really important to sort of highlight what I think a high bar this is in terms of scientifically defensible findings of fact that clearly show they are necessary to protect public health. We've seen any number of cases where municipalities normally after the fact that are trying to sort of on an ad hoc basis patch together a quote scientifically defensible finding of fact that shows a particular restriction is necessary to protect public health and safety, and the results are neither scientifically defensible nor clear nor necessary. So when any of you on this call are faced with again, especially sort of an after the fact or reactive regulation or ordinance that a municipality is looking to put in place, To me, the first thing that I look at is, is this action that is being taken or has been taken, does it meet this, what I think is a relatively high bar? So I think you're definitely right to highlight that in my view.
And since this is Dave Crass, and since you two are getting to talk about your favorite provision of the citing law, I'll just interject to me what is another extremely important provision to highlight of the citing law, and that is the rebuttable presumption provision. And that is to say that once you file an application with the local unit of government that has adopted citing, be it either a zoning approach or a licensing approach, and you show compliance with those statewide standards, or you show compliance with the more stringently adopted statewide standard, which is the provision that's being highlighted on this slide. In either case, once you establish that you have complied, that you've shown an application that is internally consistent and that meets those standards, there is a statutory presumption that arises in favor of the livestock operator in favor of issuance of the permit, which is very strong because what it does is it shifts the burden to those who are opposed to the facility to show by clear, it not only shifts that burden, but requires that opponent show by clear and convincing evidence, an evidentiary standard essentially adopted in the standard, that the application fails to meet those standards. So again, the statutory concept, very important. The first point being that there's this burden on political subdivisions that if they want to do anything outside of the statewide standards and regulate livestock operations, they have to meet that high bar that Paul and John were highlighting, coupled with the fact that once you submit an application that satisfies those statewide standards or any other locally applicable standards, there's a rebuttable presumption created in favor of the application being granted. So that's my favorite provision. I just had to get that out.
You can tell we're all a fun bunch since we have favorite provisions of statutory. So we're a lot of fun at parties, guys. But I would like to return to what Paul was saying. Some local governments have met this standard, though, and they've been able to implement more stringent local standards. It really was designed to be used. What's interesting, to Paul's point as well, is that when we're talking about examples of what local governments are doing now, they're not even trying, right? Probably because most of them realize they can't actually show that there's a scientifically sound basis for them to have additional regulations on top of what the state standards say. So instead they just kind of go it their own way. They kind of go rogue. And we'll look at some of those examples later on during the presentation. Here's just a quick map of where we have cited facilities. Those are the sort of golden or orange dots, and also where livestock citing has been adopted. You could adopt it in one of two different ways. You can write it into zoning, or you can adopt it as a licensing provision with permitting. The red or pink shaded areas there have adopted it as licensing. It can be adopted by the county or the township. You'll see some counties where the county maybe adopted it and towns within that county have, or conversely where maybe the county hasn't adopted it, but individual townships still have on their own. And sometimes not by the same means. You might have the county using zoning and a township in the county requiring it as a licensing provision. What's important to note about this slide, and something that I think not everyone even understands about citing, is it does not make a local subdivision adopt it. Now, if they want to regulate these facilities at all, this is their vehicle to do so, but they still have to adopt an ordinance and sort of opt in to doing to using these state standards that have already been outlined. So looking at that map and considering the zoning question, and you already saw sort of areas that on the previous slide, one of the exceptions is whether the area is not zoned agriculture. One of the things that sort of sticks out is could they zone ag or modern ag out of existence? And generally, local governments cannot prohibit large farms in an area zoned for ag if smaller farms with the same type of animals are allowed elsewhere. So that general statement there usually means that we're not going to run into that problem. There's an exception, though, so unless that there are other areas of the county that are where larger farms are allowed regardless of size with that kind of animal. So it's true that you can have a county that maybe gets creative with zoning. They might carve out certain zones where larger farms aren't allowed. But if they're allowing a smaller dairy farm somewhere else in that political subdivision, they need to allow farms of a larger size. And in all circumstances, that last bullet point there, always local governments cannot prohibit livestock siding facilities altogether in zoning unless they can, again, demonstrate a scientific reason to do so to protect public health and safety. That, to me, is an almost impossible bar, particularly if we're looking at sort of a county-wide approach. Maybe you could think of even a township. It's almost impossible to think of an area where there's a scientific reason that just says you can't allow livestock facilities. It'd be too dangerous to the public. Then from the statute, which is itself pretty short, maybe a page, page and a half, we go to the rules, which aren't much longer. There may be 11, 12 pages of text. There we have more details about what's actually expected of these livestock facilities if they are going to be permitted. ATCP 51, which again is the rule that supports the statute, sets out different setbacks that are expected. Here we're talking about property line or right-of-way setbacks for livestock structures. You see there we have two different thresholds, 100 feet or 200 feet from a property line or right-of-way, depending on the size of the farm and how many animal units it has. We also have property line or right-of-way setbacks for manure storage, and there in all instances that's 350 feet. There's also other setbacks that are out there that people have to consider when doing these things, well setbacks, shoreline or wetland zoning setbacks, floodplain setbacks based upon zoning. But those are all covered by different provisions in the law, but you have to be mindful of those on top of what's found in ATCP 51. It's also possible for local governments to grandfather old setbacks, grandfather old for existing facilities, and also to be less stringent than these state standards. They just have to adopt that when they're adopting their own local livestock siding ordinance. Farms generally need an odor score of 500 or more. There are some exceptions. If it's a new farm with less than 500 animal units, so rarely would those farms even need to go through siting, again, unless maybe they're in a place like Jefferson County where I live, where we have a grandfathered lower threshold. Or you're an expanding farm that has less than 1,000 animal units. Or if you're far enough away from all your neighbors anyway, 2,500 feet from your nearest affected neighbor. And it's also possible for local governments to lower the requirement necessary for all farms. They could do that again when they're writing their own ordinance. But
hey,
if
John,
one of those, yeah, go ahead.
Sorry, I just but before we move on from that this bullet point, I just wanted to point out there is sort of a carve out for the exception for the expanding farm that will have less than 1,000 animal units. And that would be a circumstance where the applicant voluntarily fills out the odor score worksheet. You might say, why would you do that? And it's a good question. I would say that a quick read of ATCP 51 might lead you to believe that you're required to do that, even though you're not, based on the way that the reg is written. And once you do fill that worksheet out, even if you're less than 1,000 animal units, then you will be required to meet the standard.
The reason for doing that is to essentially lock down your setbacks,
right.
So that you can't, for purposes of your facility, you're not dealing with someone who then moves in later within that setback distance and negatively affects your score.
Right. So just to be clear, if you do, for whatever reason, choose to fill out the worksheet, then you will be subject to the standard, even though you might be under the 1,000 animal units. And
if you're someone who's going to be doing that odor scoring process, this worksheet that protocol referenced. It'd be part of your application that you'd submit for livestock sighting. A lot of different factors go into it. They're outlined here on the slide, whether that's wind direction, considering your nearest affected neighbor, the distance from your nearest affected neighbor, what kind of animals you have, what kind of housing you're using or manure storage structures you'll have. And then you can basically tweak and adopt different kinds of practices to obtain what would be a passing score is the idea, to give you a lot of different options where somehow together you're able to hopefully meet that 500 score level or threshold that is set out for you. Things like diet manipulation, windbreaks, manure additives, biocovers. Some of those are very concrete things. Some are a little bit more fuzzy, like frequent cleaning is one of the things on the sheet that's a little more subjective in nature. And the last bullet point here actually gets at one of the things that Dave was mentioning about why you would fill out this odor score sheet even if you are not meeting the animal unit threshold, at least initially, and that's that your nearest affected neighbor is grandfathered from when you do it. So that's, again, what he was describing when you're trying to lock down what your nearest affected neighbor is. You don't have to worry about someone moving closer to your facility and then altering all your setbacks after the fact. Nutrient management's discussed. Pretty straightforward there that you're going to be required to have NRCS 590 compliant nutrient management plan. You can change that or update that. That's allowed throughout the process and after you've been permitted. And that CAFOs merely have to show that they have a CAFO permit because one of the parts of their underlying CAFO permit would be that they already have one of these plans anyway. Waste storage, different requirements are laid out for what's expected of waste storage facilities. Everything from the very fundamental that we're supposed to be engineering these things to avoid leakage, that seems like a pretty basic threshold, to how we deal with existing facilities, what new or substantially altered storages have to be engineered to. Again, we're relying on federal standards from NRCS, both 313 and 634. We're looking to ensure adequate storage capacity, and the goal there is to give yourself an extra foot of depth or room for rain in the event of a 25-year, 24-hour storm event. Again, in this instance, CAFOs only need to present their permit because the requirements for their waste storage facilities under NR 243 are actually more stringent than anything found in ATCP 51. Runoff management is also addressed. You have different standards for feedlots. Tools, of course, used to try to measure the phosphorus leaving any lot and different thresholds for what would be an acceptable phosphorus loss from those lots are used based upon the distance between the lot and a stream or a lake. Runoff cannot discharge directly to a conduit to groundwater. Again, it seems like a pretty basic standard, but the devil's in the details there, sort of getting into the question of what constitutes a direct conduit to groundwater. Sometimes is a question that hangs some people up. Measures must be taken to avoid feed storage runoff from reaching waters of the state. Clean water diversions might be required in certain circumstances. They want to keep unconfined manure piles away from 1,000 feet away from a lake or 300 feet away from a stream. And again, sort of the basic requirement of keeping cows out of the stream. There's a question of sort of how to feel about livestock sighting, whether we should view this as a limit on local government or not. I would say it is a limit, certainly. This tells them that if they want to try to regulate these kinds of facilities, this is their way to do it. So in that sense, they're limited. But there's also a lot of flexibility. So it is and it isn't. It allows local governments to impose stricter rules, but they actually have to show they're necessary and scientifically defensible. It's a way to spread compliance with our non-point program. One of the things we've struggled with always was to get a high level of participation in the non-point program, getting people into nutrient management planning. There's been a lot of discussion back and forth, especially in the last year, I'd say, about how we broaden the number of farms that are forced to participate in the non-point program, even without cost share dollars. This is actually one of the best and most effective ways to bring in a whole other group of farms that are large but aren't CAFO size necessarily into non-point program. And interestingly, even though that's true, a lot of local governments haven't taken advantage of it. After approval, local governments can monitor compliance and could withdraw a permit depending on if they see violations of the standards. So there's a ongoing regulatory component of this as well. And these rules are reviewed every 4 years to see if improvements need to be made based upon advancements in technology or information that's been gathered since the last time the rule was reviewed. That's happened twice since the rule was passed and is due to occur again this year. And local governments can and have played a role in that. The last time around when they had a committee to look at this, which now is about 4 years ago, certainly local governments were well represented. We had county conservationists and people from county health departments and things like that playing a role on that committee. So it's not as though local governments don't have ongoing input on what the rules might look like. The irony is, of course, and this is something we've already kind of talked about and hinted at, even though they have this framework, and this framework actually provides flexibility for local governments, many have gone their own way, right? Whether that's using a moratorium or crafting their own unique ordinances. They've been given kind of a roadmap of what's acceptable, but they've gone off-roading, basically. So that's where we're going to turn now.
Hey, John,
yeah, go ahead.
Input real briefly on that last slide. This is Dave. Couple things to remember is that nothing compels local units of government to adopt siting. So they could choose to not regulate livestock operations, and as you saw on the map previously, the vast majority of counties and towns have not adopted livestock siting. So they have that choice to make. And secondly, it's important to note that livestock siting was based on other programs that existed. There are other siting type statutes that existed in Wisconsin prior to the adoption of livestock siting. So although it's talked about a lot, right, in terms of our current climate, the fact of the matter is that we've got siting statutes for any number of economically important industries in Wisconsin. Power plant siting, transmission siting for electric power, cell phone towers, landfill siting, things that are important to our economy that, given that we are the dairy state, as part of a public good, if you will, with our economy, we've found that as a model to pursue livestock siting. So just as a talking point, as people may hear, negativity about the livestock siting law, is that there are many siting laws in Wisconsin, and it was really designed to level a playing field so that if something is appropriate and could be scientifically defended, then it shouldn't be subject to a high school popularity voting contest.
That's a good point, Dave. We're going to move in now to some of the more unique things that have been happening in the last few years, where, again, people sort of take it on themselves to do something different from siting, often contrary to siting, and how those things have played out. Starting with moratoria and where we've seen those. I do know that the trend has started in Bayfield County, but certainly has been tried elsewhere. Some of these have been successful, some not. I'm trying to think of every instance, and I'll look to my co-presenters to chime in if they know of other ones that I'm missing. So I know that Bayfield has had one. Again, it was temporary in nature. Ashland County also had one. One was implemented in Dunn County. One was attempted but did not get implemented in St. Croix County. One was implemented in Greene County, I believe. And then we've also had one now successfully implemented in Barron and in Pepin. And I think that might be the list, but maybe there's one or two that I might be missing.
Yeah, I'm not sure. I'm not sure you're missing any. I mean, I can tell you that we've dealt with a few of those that you ticked off. In particular, the Greene County moratorium in the town of Sylvester, which did go into effect, and it was temporary in nature. And as I mentioned earlier, was very much reactive to a project that was already underway. Not that really matters with respect to sort of the validity of the concept under livestock sighting. Not to jump ahead on your slide, but I think there's some real questions about whether you can in fact impose any blanket moratorium on livestock sighting consistent with the livestock sighting statute, and in particular with respect to the timing mechanisms, between a complete submission and a requirement that the municipality respond to that submission within a particular amount of time. So, I don't know that any of these moratoriums have been litigated out. I know that they haven't actually been litigated out to their natural conclusion. But I think there's a serious question about whether, in fact, you can impose a blanket moratorium consistent with livestock sighting.
So let me also say on that point that Paul addresses, and that is historically when we've seen moratoria be implemented, it's in a situation where there may not be livestock sighting. A project is being proposed. Let's say it's proposed at a county level, and the township does not have zoning or sighting, and the county doesn't, and so then a township goes in and tries to adopt a moratorium, and the question has always been the one that Paul highlighted: is that even a legal moratorium? We know that moratoria are designed to allow time for planning. There's a specific concept under zoning about the limitations on the length and the reasonableness of a moratorium in terms of development, but since the time that those moratorium initially developed, and now we've had a very important development in the law, and that is the vested rights statute. Mm-hmm. So now, and Paul knows this law better than I do, but I'll just try to do it in broad strokes and he can fill in. Now, if you are in a scenario where these moratoria that were developed in reaction because there was no sighting in place, right? And there was no regulation, let's say at a township level in place. Now, if you file your application for an integrated project, it is for the first permit that's required, and it may not be from that township, but the first permit that's required from any jurisdiction, any governmental jurisdiction that controls your property, you have frozen the regulatory framework that applies to you. Seems like common sense, right? In other words, you shouldn't you shouldn't file for your project permits and then have the rules of the game changed down the road. But that's exactly what these moratoria were attempting to do. And now we've had a statutory development where, and I forget the effective date of that statute, but it's prospective looking. Certainly any filing today and within the last year or so.
Absolutely, yeah. I don't know the exact date.
Is governed by that vested rights statute. So if you're currently on the ground fighting one of these that might follow that fact pattern, you really ought to look at that vested rights statute because you may have an ace in the hole right there.
Mm-hmm. And I think Dave was right to highlight maybe the one element of the vested rights statute that might not be initially at least completely obvious, that being that an application in any jurisdiction, as long as they have jurisdiction over your project, it freezes the law in all jurisdictions, and that is very important because in a number of cases, we've literally raced to the courthouse, to the zoning office, to file a building permit. Which is sort of typically the permit that might kind of be the initial shot, but once that initial application is made, wherever it might be, it freezes the law everywhere, which As Dave mentioned, essentially just make sure that everyone knows these are the rules of the game and they're not going to change.
And it's really important because in the majority of the cases where we've seen moratoria, they are in response to a certain project, which is probably already well underway by the time that we get to the point where the county or the township is looking at imposing a moratorium. That's not always been the case, but in most of the cases.
Which I'll interject, John, by the way, is a reason in the law why a moratorium should be struck down. And that is, it is not supposed to be developed in reaction to a specific project. That's one of the grounds to attack a moratoria. Hopefully, with the development and the adoption of this vested rights statute, we'll have fewer, brush wars and skirmishes over that. But these reactive moratoria are suspect from the beginning.
Right. The general trend also with them has been to tie them to a study committee. We've seen that process unfold in Bayfield and Dunn and Green, so that the idea being that while we're having this temporary freeze that might be 6 months or a year, we're going to be studying what we can do to regulate these kinds of facilities on top of siting, or maybe instead of siting, or in conjunction with siting. What's interesting about these study committees is sort of the end products. It's usually some sort of report. Now they've taken to citing each other's reports. I know we've just had a study committee report come out in Greene County not too long ago. It's always interesting to see them cite another county's study committee report as though that is some great peer-reviewed bit of science or something that they can rely on, but nonetheless, they're already doing that. And then what's also often done is they'll come up with recommendations for new regulations. And these new regulations often walk a fine line that we've always struggled with a little bit when it comes to siting, which is what are the differences between a siting ordinance and an operations ordinance. We've got a little case law on that, Dave. I don't know if you would mind talking a little bit more about that with the group.
And which case law are you referring to?
So I'm thinking about the Larson case and the footnote there.
Oh, yes. I'm sorry. I missed your lead-in, and that is yes. When the livestock siting law was initially adopted, and then many of you on the phone are probably aware of the Larson Acres case, which ended up at the Wisconsin Supreme Court, and that involved the county of Magnolia. And in a footnote in the decision, what the Supreme Court indicated is that basically we are not opining on this open question of whether ordinances that are targeted toward the operation of a livestock operation that would come under the gambit of siting is preempted. Our decision is limited to the preemptive effect of the siting of that facility as opposed to its ongoing operations. So that left the door open, right, for local units of government to say, okay, well, we're not going to necessarily zone out or regulate out the siting of the facility. Rather, we're going to focus our attention on how it's operated. And that's the lead-in potentially to your next slide, John, about some of these things that we've seen develop that really focus more on operational aspects of a livestock operation rather than its siting for the request to expand or construct.
Yeah, I just think that tension is important to highlight because we're not really sure where that line is. And sometimes that line can be awfully blurry because there's some things you could do that would be a restriction on operations that are basically a de facto restriction on ever having a farm of that size because no one would ever build there based upon that kind of restriction that you've put on their operation. The problem with moratoria, I think we've looked at that a fair amount already, both that they shouldn't be reactive, also that they run afoul of livestock siting, to Paul's point earlier. even though we didn't address it when we talked about siting directly, the siting law has these different timing requirements of when you need to have responses from local government to whether your application's complete, and also once that's done, when they're supposed to say either thumbs up or thumbs down to your application. If you have these timelines in place, how can you blow those timelines by honoring a moratorium? They're in direct conflict with each other. So again, not something that's ever been litigated, but an interesting question, at least from our perspective. It's hard to see how moratoriums like this moratoria like this could be legally justified. Getting into some of those local ordinances, in the Bayfield case, that's exactly what happened. They produced a pretty lengthy operational ordinance for facilities of a certain size. Again, none of which exist in the county right now anyway, but one that was potentially planned, so that was sort of all geared around one hog operation that was planned for the area. That's been tied up in litigation since, actually between the county and the Department of Natural Resources, where the DNR actually thinks that the county's overstepped its authority in a couple of places in the ordinance, getting into what really should be reserved powers for the state and for that agency in particular. There was some talk about a resolution to that case, but to the best of my knowledge, it's still ongoing litigation. Do you guys have any updates or insight?
I can give you, John, a quick update on that. And the state of Wisconsin took the position in that one that because you had this ordinance that was clearly targeted, it was targeted for a CAFO to come. And so its basis, the basis or rationale of its decision was to say that we need all these protections because we have existing groundwater quality concerns and existing environmental degradation, essentially, in the county. Well, what the state pointed out was, look, you cannot justify a need, go back to those early slides about, establishing a need for a more stringent set of regulations that is scientifically defensible until you've actually implemented the statewide standards in your county, and you've shown no effort or evidence that you've implemented those standards, and only after you've done that can you justify basically an approach that would be more stringent than that. The case ultimately was remanded to the county to essentially file a new justification document to try to justify their findings. That was filed with the DNR, and DNR on March 22nd issued its rejection again of the Bayfield County ordinance, basically saying that, or concluding that the county failed to satisfy the requirement in both NR 151 and WSStat Chapter 92, because it did not document that it needed these more stringent requirements in order to comply with groundwater quality standards, because it had not even implemented the other standards that are applicable to livestock operations, i.e. NR 151. And that decision of the DNR has not been appealed. So their time has passed. The county has not neither appealed administratively or by judicial review this March 22nd decision. So that case is over, and the ordinance does not stand in Bayfield County.
Thank you for that, Dave. We have listed on there a couple of items dealing with manure irrigation. First one is Wood County. That one's near and dear to my heart. I'm coming up on my 4th year anniversary with DBA, and this is the first local ordinance hearing I had to go to, was one on this Wood County strict prohibition of irrigation with tea water or manure and water mix. That ordinance had a kind of an up and down fight there in the county. It's interesting to contrast, I think, actually with what Kewaunee County is doing or has been working on more recently, which is actually an ordinance geared to probably allow manure irrigation, but sort of putting sideboards on it. I'm not sure they've really found the right balance there yet either, but it's a real evolution in thought, I think, from a strict prohibition like Wood County was looking at to something where Kewaunee is now talking about how do we make this workable, and maybe I know the county's even been working with townships that had strictly prohibited the practice, that if we get this countywide ordinance, would you lift your local prohibitions? With some success, and also, at least in one instance, a town that still refuses to do that, but sort of an interesting development on that. At the same time, Kewaunee County's also developed an ordinance requiring certain training and documentation requirements for people who apply manure. This applies both to farms, all the way down to a fairly small farm, and to custom operators who might be working with farms of various sizes. Again, kind of, at least these last two from Kewaunee County, I think kind of innovative. Hard to know exactly. Parts of them probably are good, and parts are a little bit more troublesome, but just very interesting approach, and one that I don't think really we've seen much elsewhere in the state. Then we have two towns in the southern part of the state, both reacting to a potential new dairy. One that's not going to have a new dairy because of their ordinances, and one that, despite their attempts, is going to have a new dairy. And that's the town of La Prairie and town of Sylvester. I know you guys have been much more involved in both of those. And I don't know if you'd like to comment on what you've seen in what we saw in both those different towns.
No, pretty much the same MO as we've been identifying. I do think what is interesting about all of these, and I know Paul will talk in a minute, John, about the Frymouth case in Walworth County, I believe that was, because there is there are a series of holdings by the Livestock Facility Siting Review Board, which is another cool thing created by the livestock siting law, and that is that you don't have to go to court necessarily for relief. You can go to basically an interim oversight board to obtain relief to the extent the local unit of government oversteps their bound. But in all of these, with respect to manure, irrigation, we saw groundwater ordinances, et cetera. You do run into where, I guess it's just an additional highlight of where does an operational ordinance, tread onto what should be preempted in terms of the siting law. And so I think all of these are sort of just different. Their facts vary slightly, but they're all sort of attempts to frustrate. And I would also say that, not only the activist opponent groups, but also some local officials who are opposed to livestock siting in their jurisdictions, they are all very well networked now with respect to these approaches. So this is something that we expect to see more of rather than less of moving forward.
Yeah, no, I think that's all definitely accurate. A little color, for example, with respect to the town of Sylvester, probably one of the biggest thorns in the side of that project ended up being, of all things, a driveway ordinance that was just frankly improperly applied. But had the operational effect of, for a long time, months or, over a year maybe, preventing the applicant, in that case, from obtaining a building permit, a zoning permit, to construct the dairy. So, it's an example of whether it's, a zoning law or some other aspect of a local ordinance, almost anything can be used as a weapon if if it means that it's going to delay or potentially kill a project that the folks that have some say so don't want to see happen. Dave mentioned the Fremont case in Walworth County, which I think is interesting for a couple reasons. First of all, it's quite recent. I think the decision was handed down by Livestock Sighting in January of this year, so just a couple months ago. Just a very short background. Applicant was an existing operation, wanted to expand up to just shy of 1,000 animal units. The Walworth County has a livestock sighting ordinance that requires that the applicant obtain a conditional use permit, CUP, as a condition of an expansion like the one the Fremonts were considering, which is, by the way, not inconsistent with livestock sighting. A municipality can require a conditional use permit. It still has to comply, of course, with the livestock sighting statute and ATCP 51. So to make a fairly long story somewhat short, CUP is issued with a number of restrictions that I'm told have always been included with every CUP for livestock sighting in Walworth County, several of which were, I think, pretty clearly operational. For example, no transport of animal waste on roadways between 6 p.m. and 6 a.m. Applicant, there's a whole paragraph that I'm not going to read to you about manure storage requirements, but it included, among other things, storage facilities must be emptied within 2 weeks of any time spreading begins. Number of requirements like that. Applicant responsible for cleaning tracked soil or manure off of roads in the township or county. So, pretty clearly operational type restrictions. And the applicant challenged those restrictions in the CUP. Well, and in fact, the neighbors challenged even the issuance of the CUP. And the Livestock Sighting Review Board not only, well, they sent it back down for some procedural reasons, but they essentially upheld the issuance of the CUP, or at least the right of the Fremonts to expand their operation. But they also, and I think notably with respect to the question of, the distinction between operational and non-operational, they struck down those restrictions that I just mentioned with regard to hours of operation, cleaning, soil and manure from roads, etc. So, there is at least some authority out there. Now, granted, this hasn't made its way, all the way through the court system, but there's some suggestion out there, at least based on that case, that, operational restrictions, would be within the scope of livestock sighting.
Yeah, and that decision, as Paul noted, gives us something to cite to if we end up back in front of the Livestock Sighting Review Board based on, these types of onerous operational conditions of an approval.
Right.
Another type of local ordinance, you were talking, Paul, about this driveway ordinance. I think another place that we see this come up much more common, at least when it comes to this kind of expansion, might be a manure storage ordinance. A lot of leeway given to local governments when it comes to crafting these ordinances. I know, Dave, you had wanted this issue flagged, and I think it's a good one to sort of bring everyone's attention to. Is there anything you'd like to add about that?
Yeah, and real quick, because I know we're short on time, we are handling a matter right now where, the county issued 2 permits. They issued a livestock sighting permit, no problem, away we go to build. But then they also issued a manure storage permit, which arises under separate statutory authority that the county has to issue manure storage permits. And what the manure storage permit includes conditions that are inconsistent with what one would be required to comply with under sighting. And when you layer in the Fremont decision that Paul just mentioned to you about, how the manure storage has to be operated, what is the interesting question there is, do we have our sighting permit, the sighting permit is clean, it's not encumbered with these extra state requirements, if you will, or requirements that go well beyond what other facilities are required to meet, but yet we have it arising in the context of a manure storage permit. So that, I think, will be another area to come where we may see local units of government who have the power to issue, who have a manure storage ordinance, right? And in fact, that's where some of them have acted in terms of the restriction on manure application and the restriction on let's say, manure application via center pivot or drop nozzle irrigation. They've pointed to manure storage ordinances that require, nutrient management plans, and they've tacked some of those restrictions onto those. So the landscape here is sort of ever changing. It's a little bit of whack-a-mole, and we want the DBA membership to know that DBA is keeping a close eye on these developments, and as new creative theories come up, we will have to remain vigilant in defending the livestock siting law and what its legislative purpose is underpinning it.
Thanks, Dave. And I'll just touch on those last couple of bullet points very quickly as well, just because of their uniqueness. And it kind of goes to Dave's point about how these things are kind of all over the boards. They're just using whatever vehicle they can get. We have these IOH ordinances really meant to regulate equipment weight on roads. But we have had some instances of towns here, two highlighted in Lane County, that have kind of used those to be more operational in nature. They might restrict days of the week or timing of manure application through their IOH ordinances. They've attempted to require certain pretty onerous bonding requirements on farms above and beyond what's ever been attempted or tried before. Again, not really something that was anticipated by those passing the IOH law. Arguably not legal, arguably contrary to citing, but out there and being attempted by the towns at least to be enforced against a couple of farms right now. And that last one is an attempt actually in Jefferson County to regulate just one particular kind of large farm. There they were trying to regulate large goat facilities based upon a Q fever concern, so basically a disease concern. It's, of course, a disease that all ruminants can get, so it's not limited to goats anyway, but this is sort of this oddball attempt to regulate just large goat facilities, again, in response to a planned or submitted plans for a larger goat facility. That ordinance was ultimately not successful, though, in part because of local agriculture's response to that, which was very strong, and some help from DBA as well. As we've kind of discussed throughout all of this, we're really walking a fine line between these ordinances, between what might be a creative response by a local government and what's likely also, in many cases, an illegal or unlawful extension of their power beyond what they've actually been given by the state. There are a lot of things that maybe we could look at, and I might want to keep time really for questions. Just to let you know that we are looking at perhaps different ways that we can respond. One of the challenges, of course, is farms. It's the question of, do you want to build your farm and then have to litigate the legality of it? How are you able to most effectively, in a cost-effective manner, litigate what you view as an illegal ordinance? There's been some talk about the creation of a new cause of action for farmers and other people impacted by these kinds of laws, where you could seek declaratory judgment against these types of ordinances. It'd be a quicker, cheaper thing you could do at the outset, so you could strike down the law before you had to sink additional investments into trying to move forward with a project. There's probably other ideas as well as for what can be done, but instead of dwelling on those, knowing that we've already reached our hour, I'd like to open it up for questions if there are any. If they aren't, if we don't get a lot of questions, we might come back to that question and kind of kick it around a little bit. But first, we'll open up the questions. You can unmute your phone and ask directly, or you can also type your question in the chat box in the lower right-hand corner. Any questions? Seeing none, I want to again thank our sponsors, CompTIA Financial and Nutrient Advisors.